I do thank you for joining us here at Nooga Radio. David Tulis. We want to ask now a question. What is an arrest? We've been talking a lot about arrests here in Chattanooga, and in the last week we made arguments about the Miranda rule, and I'm asserting that Miranda should be read. The Miranda warning should be read the moment you're arrested, because that's what, after all, that is what the Chattanooga Police Department's arrest procedures manual says on page 6, 13-page manual. It says that the Miranda warning should be given immediately after arrest to avoid there being loose statements that can't be then used in court. I had to find out more about the whole idea of arrest. I have a noted attorney here on the phone with me, Jerry Summers. Jerry, what is an arrest, and how does my listener know when he's arrested? What dynamics are in play, and how does he best protect his own interests?
Well, David, it's a good question, but it's not a simple question. It depends a lot on a lot of the facts and circumstances. But basically, it deals with the question: are you a suspect? Are you under investigation? Miranda has evolved quite a bit since it was enacted back in, I think, in 1966 in a 5-4 decision by the Warren Supreme Court, which was much more liberal than the subsequent Supreme Courts under Justice Berger. And it's changed. Different facts and circumstances make a difference. But basically, I'm not here to obstruct the law enforcement, but basically if a person wants to rely upon their rights, certainly that they may ask the officer, am I under arrest? And if he says yes, then they say, I would like to speak to a lawyer. If he says, no, you're not under arrest, but I want to ask you some questions, say, well, I'd still like to talk to a lawyer. Now, that doesn't always endear you to a lot of the police officers, because it's going to make their work a lot harder. But the question you direct to me is, what individual rights does the person have? And a person does have the right to be known. And the case has evolved, and Miranda, everybody says you have a right to remain silent. You can't afford an attorney to appoint you. All those rights, which I've simplified, are applicable. But the law has changed significantly to make exceptions on that question. And like you had asked me about a DUI stop, and I will tell you, the United States Supreme Court in 1984 stopped a guy for a suspected DUI. And there was some roadside questioning, and then they questioned him at the jail. And they did not, the question is whether the suspect's freedom of action or movement is curtailed by a degree associated with a formal arrest. Now, that's legal mumbo jumbo. But what happened in that case, there was 2 questionings of this individual, and he was not Mirandized. And the first one, it deals with both of them deal with the level of custody. In the first one, at the roadside, he was not in custody, and the Supreme Court in this decision, Berkheimer versus McCarty, said that Miranda didn't apply at that point. But when they took him to the county jail and put him in custody, they said that Miranda did apply, and he should have been advised. So you've got to see that there's been an evolution of cases with different courts. The Berg Court was very liberal, very protective of individual rights. The Warren Court was less protective, even though some of those members, as you go on down the history as far as the cases, that some of them basically, when Congress, what happened after Miranda was ruled on, of course, Miranda went back and got a new trial, and he got convicted, and then later on he got in jail, and then he got parole, and then he got killed in a bar out in Phoenix. But basically, there was a big hullabaloo that this was going to open the courthouse doors for everybody, this ruling by the Supreme Court. There was even an effort to try to pass, that enacted a law under the statute of 18 U.S.C. 3501 that would basically limited Miranda and would go to what we call a totality of circumstances standard. That case did not get until the U.S. Supreme Court, up until a case called Dickerson versus United States in 2001. And basically what they said, that the right to counsel under Miranda is a constitutional right that cannot be superseded by an act of a legislature or Congress. Now, let me go back a little bit. After Berger Court was in existence, You had John Mitchell, who was Attorney General under Nixon, but most law enforcement agencies accepted Miranda. And a lot of times, even before Miranda was decided, there was a high percentage of courts that were up and advising people of their right to remain silent under the Fifth Amendment and their right to due process of law and counsel under the Sixth Amendment. The big hullabaloo that is going to cope in the courthouse, yes, there are isolated cases that where there have been abuses, but if you go back to a history starting back in 1936 in a case in Adams, Mississippi, where they hung a guy almost. They wouldn't let him die before he'd confess. You got another one up in Tennessee that was in 1944, where a guy was held incommunicado for 36 hours before he confessed. Those abuses are pretty clear cut, and Miranda has helped to eliminate a lot of those. And actually, the fact it may help that there may have been people that were coerced in conviction and may or may not guilty. We have more and more emphasis now on the cases where people have been convicted. DNA tests are done, and they found out they were not guilty. So the criminal law has evolved substantially since this Miranda decision, and it's just one part of it. But I would think you'll find that the Chattanooga Police Department, they've got legal counsel. They can advise somebody. Obviously, it's more work if someone wants to rely upon a lawyer. And of course, they're not going to get a lawyer out there at 2 o'clock in the morning, except on very unusual cases. But it's to the benefit of the police department to follow Miranda, to advise people if they are under arrest. Now, some officers will accept that. Some officers do it routinely. Others will bow up and, wow, you're going to be that way. You're going to lawyer up on me. You know, I'll make it rough on you. I know I'm talking about specific cases that I know about over the last 50 years. But basically, if you make them work a little bit, some of them get hacked off. Some of them don't. Just say, well, you know, you got rights. It's like if I was charged or my kid was charged, I'd like to know they had those rights. So it's very variable as to what the situation is. And Miranda has come a long ways in regard to, for example, now the exceptions that have been made on Miranda are there's 3 or 4 of them. They're very simple. That in 1971, in Harris versus New York, they held that if a defendant took the stand, that he could be impeached by his statement, even though it would not have been admissible. In 1974, they indicated that, well, because the Miranda rights were not completely in complete form, that didn't mean that they couldn't use it if the vast majority of it was given.
We're talking with Jerry Summers here.
In 79, the case at North Carolina, that they say that an implicit waiver, whatever that means, not an explicit waiver, was sufficient. And finally, in New York case versus Quarles, several years later, they up and said that if there can be a public safety exception, where there's a question about whether there was a gun that may have been in a house and so forth, that location of a pistol made by in custody suspect was admissible against him despite a failure of the arresting officer to advise him of his Miranda rights. The court said that to ensure that further danger to the public did not result from the concealment of the gun in a public area. And that was decided, I think, back in 1984.
We're talking with Jerry Summers, and let me just ask you. Go ahead.
Go ahead.
Well, all right. I just wanted to. There's a stream of exceptions that you're making here, but I want to get back to the fundamental of Miranda. Miranda still, by and large, holds, as you might say, as policy. It's not law because we know high courts don't make law; they just give opinions on law. But Jerry Summers, you're a noted attorney here in Chattanooga. Have had many successful cases, including one that I've been thinking a lot about lately. That's City of Chattanooga versus Davis. The Miranda rule in the Chattanooga Arrest Procedures OPS 42 manual says, although these warnings must be given only before interrogation takes place, it is a good practice to give them immediately after arrest, thereby making any offhand remarks or other voluntary comments by the offender admissible in court. The question, I think, is, okay, it's policy that every police officer, when an arrest takes place, has to read my listener and his family members and everybody he knows his Miranda rights. But the question, I guess, is what is an arrest? And that's, that's the question I have. We have cases that are cited in the chapter of Tennessee jurisprudence, the encyclopedia that cites State versus Raspberry in 82. and State versus Garcia in 2003, citing the Terry standard. And they say essentially, Jerry Summers, that a stop is an arrest, is a seizure. And if you're on the side of the road, for example, where many people like my listener have their police encounters, that stop is an arrest. And so Miranda should be read at every traffic stop, because that is an arrest. It's not, an officer doesn't pull over a traveler or a motorist or an operator of a motor vehicle without there being some reason for it. What do you make of what is arrest?
You'd be a good defense lawyer. You're advocating very vigorously, but as I told you the other day, everything is not black and white. When you get down to the practice, one little circumstance can change the entire ruling. And the best thing to do is, as you asked me, would be for an individual to ask them, am I under arrest? And if they say, no, you're not, then you've got to make a decision. Some people get scared and think they're going to talk their way out of it. I don't say that. I mean, it's going to be a court to decide whether you're really under arrest. I'm telling you, the safest thing is to be respectful and ask the officer, am I under arrest? If he says, no, I'll ask you some questions. Still, the best thing to do is, well, I appreciate that, but I'd like to have an opportunity to talk to an attorney.
Well, the question, it seems like, Jerry Summers, it seems like one question is, am I under arrest? But the follow-up question, which has to have a different answer, is, am I free to leave? Because if you're not free to leave, then by definition, you are under arrest. You can't have it both ways. The officer cannot have it both ways.
Well, once again, David, you made it too black and too white. If you're free to leave, there's also a case law, and we don't need to go into it, is that how long can they detain you without keeping you, formally charging you? Now, that's a matter of there's case law in Tennessee that deals with that very specific issue. And let me just say this. The current Tennessee Supreme Court, in my opinion, I'm not being disrespectful to them, but they are appear to be in some of the rulings they have made lately, are more protective of law enforcement rights than they are of defendants. Now, I'm not saying they shouldn't let in particular cases, but I'm saying to you, you raised a question there. Are you free to leave? Well, if they're conducting their investigation, they may say, well, we're not going to, we need you to stay here a little bit longer before you can go. And just say, well, I'd like to reflect. I'd like to have a big chance to call my attorney. They say, well, hell, call him. He ain't coming out here anyway, or she. But I'm saying to you, that's just every set of circumstances, David, is based on another set of facts that you have to put them in there before you can come to the conclusion, as you are very simply want to make it, and I respect you for that. Am I under arrest? Am I free to go? The safe thing to do is be polite, exert your you have the right. Most people think it's, only the guilty would be the ones who assert their constitutional rights. That's not what the Constitution is about. It's about you being protected, and if you do it in a polite way. Now, if you want to be a horse at rear end, you'll pay the consequences.
Well, let me ask you this, Jerry Summers: can an officer convert the assertion, the invoking or the assertion or protecting of a right into a crime? Can an officer do that?
Can he do what?
Can he convert the assertion of a right into a crime? In other words, I'm not answering your questions. I make no statement.
Convert it. A court, if he decides, well, okay, you rely upon, you don't want to talk to me, I'm going to charge you. If you talk to me, I was going to help you. I think that he's got a problem if the judge has got any testicles when it comes up on the hearing on the thing. But, if it's any way, David, if it's some way, the idea is to coerce you into making admission against your own private interest, the best thing to do is don't answer any questions. Ask for an attorney. There's an old saying I've used it for years. There are very few deaf and dumb people in jail, and a fish wouldn't get caught if they didn't open their mouth. That maybe sound trite, but if you think about it, there are more people that are solely in jail solely because they opened their mouth, and they may not have really been guilty, but they said something that was interpreted as being an indication of guilt, and they wound up. He came back biting them in the posterior.
Well, and that's right. So you're in jail because of your own flapping gums. So the best reason the officer fuel for the supporting of his articulable claim for probable cause or reasonable suspicion, the more you talk, the more you can fuel his justification for stopping you. The less you talk, the less he has. And so you want to, I think the listener, Attorney Jerry Summers, the listener wants to put the officer on notice that he knows his rights and is going to defend them. And so he's going to ask the tough questions, which is, am I under arrest and am I free to leave? You can't have the same answer for both of those questions. And if he's under arrest, then say nothing.
One's a continuation of the other one, David. The main thing I'm going to say is you better be polite and say, I respect your position, officer, but am I under arrest? If he says no, okay, then you say, am I free to leave? And then he's going to say, we'll conduct our investigation. Well, then at some point, the question is, what is a reasonable investigation? What is a reasonable period of time? And what evidence did they have to cause them to keep you there?
Yeah, and that investigation, Jerry Summers, is based on there's no rational choice. Then the listener just needs to keep his mouth shut because the investigation progresses only because he's speaking to the officer. If he stops speaking, well, then the investigation really doesn't have a lot of grounds to go unless they want to get a search dog.
I think you're right. I agree with you.
Well, listen, changing topics. What is the effect of the case that you brought before the high court in the Davis case in 2001, City of Chattanooga versus Davis? Basil Marceau is arguing that this case has tremendous implications for the whole judicial system, in that he says it does not allow for city and municipal corporations to operate police departments which enforce statute other than statutes that are adopted by the city. What's the situation in Chattanooga?
All right, David, let me tell you the history. This was back in the days when Judge Walter Williams was on the bench. And Judge Williams, and first of all, let me say this, I'm sympathetic to the fact that he's had some health issues, but he's recovered, and he's being considered to up and go back as an administrative law judge to hear misdemeanors. I will also tell you that the problem with one of the things, the Davis case and another case got in difficulty is that under the state law, except for exceptions where there's been a specific ruling like in DUIs, a city judge, municipal judge, is limited to $50 fines. Judge Williams was fining people $1,000, and he was a darling of the city council, and he went before them and asked for a pay raise, and they gave him one, which is in blatant violation of another article of the Tennessee Constitution that says the judge's salary should not be raised or lowered during their term of office. Well, and that was part of this ruling and other cases that I have. Now, as I understand, he is being appointed as a backup to Kyle Hedrick, who is the administrative law judge that hears these ordinances, which I don't need why they have to have one, and they got two good city judges could hear it, but it's a revenue enhancement. And then Judge Williams, I hope he shows a lot more restraint in fining people if Mr. Hedrick is up for appointment to being a circuit judge.
All right, that's the question, Jerry Summers. Is Judge Walter Williams in his new position going to honor the case that you brought before the high court, Chattanooga versus Davis? $50 fine is the limit on fines, and fines are not punishment.
You got to understand, he's not under that restriction now.
Why not?
He's going to be restricted. Well, because in the case, if you read the Davis case, there's another case, Barrett, it was decided with it at the same time the Supreme Court, and they said that under a city ordinance that a judge is not limited to $50. Well, the ordinances in the city of Chattanooga carry fines up to $500. Now, if that means if you don't cut your grass short enough, or if you left your garbage can in the wrong place, or some of these other things that I say are revenue enhancements, mainly for the city of Chattanooga, they get a few complaints, oh, it's bad for the neighborhood. But the truth of the matter, they're trying to raise money, and that's what got them in trouble before. And I hope that Judge Williams has learned a lesson. He may not, but in regard to the fact that these people that come in there and their grass needs to be cut, that if he fines them, fine them $25 or $50 instead of turning it into another revenue pot for $500 fines. Because the Supreme Court in that second opinion, if you read it, they say they are not limited to $50. So that's the thing that I'm concerned about. I hope Judge Williams I'm glad he's well. He's back. He had a very serious illness, but he's back. But I hope that he's learned something from the previous experience that we had before.
Well, this is David Tulis. We're talking with Jerry Summers, who's a noted attorney here in Chattanooga. Jerry, how can my listener get a hold of you and your law firm in case he has a problem? What's your number?
Well, it's 265-2385. I hope they don't have any problem, but that's some number I have when people do. And but you know, the main thing is, you don't have to call me. But if you need a lawyer, call somebody. We got 1,200 out here in Chattanooga that do a good job, not just the ones that advertise on TV in personal injury cases, but we've got good lawyers that can answer your question. I'll be glad to talk to him about it.
Yes, sir.
But I'm not saying that being disrespectful. But each one of these cases has to be decided on its own specific facts.
Thanks for joining us here at Nooga Radio. Thank you very much.
Anytime, David. Thank you very much.
This is David Tulis. We're talking with Jerry Summers, who's an attorney who brought a very noted case that we've mentioned quite a few times. That's Chattanooga versus Davis. We're hearing about the right of the listener pending arrest. Right, when you're stopped by the officer, how do you deal with this officer? He says, be polite, and if you want to assert your rights, do so politely. But say, am I under arrest? Am I free to leave? These are good questions. Jerry Summers says, but Miranda has been modified. There are some exceptions, as he points out. They're not fundamental, though, and the Miranda, the requirement for the reading of Miranda rights is in the police policy manual, a 1966 decision that still has a claim on policy and actions of officers today. David Tulis.
Traffic, news, and information. Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM.
Hey, dude, check this out. Have you ever seen one so big?
Whoa, look at the size of that.
This little itty-bitty one.
Wow, that's really small.
They have them big, small, and everything in between. You'll always find the biggest variety of knives at the knife shop at Frost Cutlery in Ottawa. We're talking about over 40 brands of knives, including Benchmade, WR Case & Sons, Booker, and all the Frost Cutlery brands. Now, Sam, you've been to the cutlery shop. Is it amazing?
Spectacular. The knife shop at Frost Cutlery in Ottawa. They have knives, swords, kitchen knives, ammo, and reloading supplies, plus survival gear.
It's the knife shop at Frost Cutlery. Open 7 days a week. Hey, girls, you're going to love this. We're going to the knife shop.
Hey, let's not tell them they have ammo and loading supplies.
The knife shop at Frost Cutlery opens 7 days a week. You'll always find